Welsh Fishermen and Friends of the Sea against the Minister of Planning and Housing.
Good morning.
If it pleases the Lordship, my name is Fayad Hussain, and I lead Mr. Rishi Das and Ms. Marina Narayansing for the appellant. We're instructed by Amy Kwan of the firm of Simons and Moorhead, who should be in London. Thank you very much for accommodating us with this teleconference in appeal. It's a historic occasion for us, and I believe it's the first time it's done in that. So thank you very much for that.
It's a great pleasure to be able to do so, and we hope that it proves a convenient way of dealing with matters. One small point which may be useful, in case we wish to interrupt you or counsel when we are speaking, I think it may be a good idea for us simply to raise a hand so that you know that we want to say something, because if we start to talk across you, then you may not hear, and there may be confusion.
Thank you very much, my lords. I understand there's a 5-second delay in transmission, so I will try to speak slowly and do the best we can in the circumstances. Thank you very much.
Good, right. Well, we've read the written cases and we found them on both sides extremely helpful. So we now listen to you to elaborate your position as you wish.
Much obliged, my lords. My lords, this is an appeal from a decision of the Court of Appeal of Trinidad and Tobago, comprising Justices of Appeal Barrow, Smith, and Mohammed, delivered on the 16th of July, 2016. The decision of the court was delivered by Justice of Appeal Barrow, with whom Justice of Appeal Smith and Mohammed concurred. The decision of the Court of Appeal overturned the first instance judgment of Justice Rampasad, delivered on the 18th of October, 2012. The judgment of Justice Rampasad was in favor of fishermen and friends of the sea, and in that judgment he made orders to effect as follows. Declared that the methodology of employing a flat fee or fixed fee structure used by the minister, who is the respondent in these calculated the annual permit fee under the Water Pollution Fees Amendment Regulations is illegal, ultra-vires, and contrary to national environmental policy, as well as the Act, the Environmental Management Act, the policy of the minister responsible for the environment, and the policy of the Environmental Management Authority, customary international treaties to which Trinidad and Tobago is a signatory. Further declared that the Water Pollution Fees Amendment Regulations 2006 not be implemented and are enforced by the authority unless the respondent minister considered and applied the pollution pay principle in calculating or determining the annual permit. To that effect, he ordered certiorari to quash the decision of the respondent minister, and mandamus granted asking the minister to properly use and consider and apply the PPP and calculate and determine the annual fee. Now, perhaps before I can begin, my lords, I can quickly introduce the parties in this matter. The appellant is a Fishermen and Friends of the Sea NGO, who is engaged in public advocacy in respect of environmental matters, and is incorporated under the relevant company act in Trinidad and Tobago.
Can I interrupt for a moment? Your voice is slightly breaking up. Now, it may be, I think we will be entirely happy if you wanted to address us sitting down, but it may be that it's simply the distance between your voice, your mouth, and the microphone. I'm not sure why it is not entirely equal in its projection.
Per-
But we're very happy.
Perhaps I can lean forward.
Yes, that's
I prefer to stand, my lord, but is it better?
Yes, that's better. We're very happy that you should sit down if you wish to, but that is certainly better, yes.
If it gets any worse, or if it deteriorates, perhaps my lord might advise me, and I can probably sit, but I prefer to stand there.
Yes. No, that is better. That is better.
Thank you very much, my lord. My lord, the respondent is the Minister of Planning, Housing and the Environment, and is responsible for the promulgation of regulations made under the Environmental Management Act. Perhaps I can define the legal landscape in this matter before I begin, so we can have some of the references shortened, so I don't have to continuously refer to the full title of either the regulations or the rules, as the case may be. And the legislative landscape is as follows. First of all, there's the Environmental Management Act, and that act was passed in 1995. That act was, however, repealed and passed again in Parliament in 2000. And the reason why exactly the same act was passed in 2000 is not of material interest in these proceedings, but it was done merely to satisfy the constitutional modalities prescribed by Section 18 of our Constitution. So I'll probably refer that from time to time as the Act or the Environment Act, as the case may be. And that is the only piece of primary legislation we are concerned with in this appeal. Now, there are two other pieces of delegated legislation which I think I ought to get out of the way. The first one is deals with the the water pollution rules. The water pollution rules were made in 2001, and the dates are significant because it helps with the chronology of the reasoning in this matter. It was made first in 2001 under the stewardship of Minister Adesh Nanan, and that is important as to which minister made these regulations. These rules, Water Pollution Rules 2001, went through a period of consultation under Section 18 of the Environmental Management Act, and thereafter, after consultation and preparation with the authority, they were laid in Parliament. And the distinguishing feature about the rules is that the rules were made by the minister. That is important because there is a substratum of is a statutory substratum or statutory underpinning of the rules. The minister made these rules, and a respectful submission, the minister ought to follow these rules, and the minister can alternatively amend the rules as the case may be with the Act. Now, after 2001, again were made in 2006. These rules were similar to the 2001 rules. No material difference for the purposes of this case. So if I refer to rules at all, they refer to the 2001 rules and the 2006 rules. And there's no material difference between them for the purposes of this appeal. The second bit of delegated legislation, regulations. And these regulations were again made by the minister, and these regulations were made under Section 96 of the Environmental Management Act. These regulations were again made in 2001 by Minister Adesina, and then subsequently in 2006 by Minister Beckles. I referred to the water pollution rules and the pollution fees regulations as the regulation. Now, the distinguishing feature about the regulations is that in 2006, the entire schedule of the 2001 fees regulations repealed and replaced in 2006. But what remained the same was a $10,000 permitting fee, which had to be paid by all permittees, irrespective of quantity, toxicity, or the volume of pollution released into the receiving environment. We challenge, of course, that portion of the 2006 regulations that imposes a fixed fee, a fixed permitting fee of $10,000, because we say that defies the policy of the minister. There are two other bits of policy which I think is going to be material to this argument. First is the national environmental policy. The national environmental policy was made, first of all, in 1998, and it was made by Mr. Mohammed. And my Lord, see from the record of that Minister Mohammed was in fact the minister from 1995 to 2000, and he posed an affidavit in the proceedings. He is the one who made the national environmental policy in 1998. Now, this policy, 1998, this policy is important because this policy was made under Section 18 of the Environmental Management Act, and it was laid in Parliament, so the minister takes responsibility for it. And under Section 31 of the Environmental Management Act, Section 31, the minister and other government officials are mandated to follow this policy. So that is the policy, it's the National Environmental Policy, and it's really the framework around which the implementation of the Act is based. So that policy was subsequently amended in 2005 by Minister Beckles, and there's no material change insofar as paragraph 2.3 is concerned, which is really the focus of this case. That material paragraph. And in 2017, there are attempts to have a new policy which was published, and again, the paragraph 2.3 remains exactly the same, and that is the focus of attention. So I'll refer to that as the policy, my Lord.
Lord Wilson has a question.
Mr. Hussain, I'm sure it's my fault, but I haven't quite been able to understand yet whether the words in section 2.3 of the policy, which we've got in tab 9, namely the revised policy of 2005, were precisely the same as the words in the initial policy in 1998. What's the position about that, please?
They're exactly the same, my Lord.
Thank you.
Might I just refer you to those words because I think they're material. They are in the electronic bundle at page 943. And perhaps I could say make a few brief remarks about them.
Wait a minute. Wait a minute. Let us find 943.
Well, that's his case.
In your case. Yes, thank you. Yes, yes,
13.
2.3 provides as follows. A key principle of pollution control is that the cost of preventing pollution or of minimizing environmental damage due to pollution will be borne by those responsible for pollution. The principle seeks to accomplish the optimal allocation of limited resources. Full stop. Important elements of the principle are, and charges are levied as an application or processing fee, purchase price of a license or permit, which entitle the holder to generate specific quantities of pollutants. And it's conjunctive. The money collected will be used to correct environmental damage. That latter portion contained in B is really the heart of the appeal, if I may. Because we say in summary, what happens is that what we say, I'll have to sit a lot because I think there's a malfunction here and I need to sit. Is the reception?
yes, we can see you now. I'm sorry about the problem, but we can see you,
Okay, thank you very much.
the whole courtroom, yes.
Thank you very much. The case really turns on the conjunctive part of 2.3. That is, monies collected will be used to correct environmental damage. Now, I was at the point, my lords, where I was sort of mapping the policy framework that is going to guide these proceedings. And my submission is that because of the fact that the policy, national environmental policy, is statutorily underpinned, it occupies a very high shelf in the hierarchy of things in terms of how it is that the consideration that should be given to it by the minister in making his regulations. The final part of the puzzle is the water pollution management program, which I will hereafter refer to as the program. Now, this program is not a program of a minister. It is the program of the authority. And that program was first made in 2005 during the tenure of Minister Penelope Beckles. I pause to make a number of points which I think is going to further put the light on what these proceedings are about. The first issue is that because we challenged 2006 regulations in respect of the fixed permitting fee, in 2006, when Minister Beckles made or laid in Parliament the 2006 regulation, she had available to her the following documentation which she did not comply with, and which she might have in one case been bound by, the other case she ought to have some consideration. She did not comply with 2005 National Environmental Policy, which is the document which is statutorily underpinned under Section 31 of the Act. She did not comply with that. And she did not comply particularly with the second limb of point 3. Mr. Beckles also did not comply with the recommendation made by the Environmental Management Authority, which is the regulatory body established under the Environmental Management Act. And that National Environmental Authority in 2005 made the Water Pollution Management Program, the program in which they recommended a model called the pollution load model. And what Mr. Beckles did in 2006, when she laid those regulations, we really followed a model called the egalitarian model. Now, in a nutshell, what our case is that the failure of Minister Beckles 2006, when making the regulations in respect of a fixed permitting fee, she first of all failed to follow the policy, and more particularly 2.3. She was mandated to follow because it was statutorily in. And she also, just by way of note, did not follow her own, or did not follow her own national environmental policy, and did not follow the authorities, which was made by the authority in 2005. That is the framework, my lords, on which I propose to develop my submissions. And perhaps I can begin first of all by dealing a little bit about what is the pollution pays principle. Now, I readily see the following things. First of all, the polluter pays principle, known affectionately as the PPP, is a principle of environmental law that is jurisdiction specific. So therefore, it depends on how much of it and how you interpret it in respect of each particular jurisdiction. The philosophical underpinnings of the polluter pays principle is that there's need to strike a balance between the cost of commercial production and the adverse impact therefrom on the wider society. So we developed the principle that the society owns the environment. Therefore, persons who operate industrial facilities or any facilities at all which are polluters, they ought not to externalize into the public pollution and reduce their cost of production, because what they'll be doing is impacting everything in the environment and having an impact on the society's ability for future growth and long-term enjoyment of the environment. So the principle is developed that as much cost as possible, if not all, should be internalized by the polluter who produces the product. Therefore, goods should be sold at the market value, including the cost that is involved in disposing properly of waste pollutants as the case may be. If you allow persons to pollute, what they can do is considerably reduce the cost of production, and there'll be unfair competition in the world. So the principle is developed on that basis, not to assume a correct mechanism in terms of trade, but in terms of the environment. Now, this principle, my lord, first of all, I can deal with some of the soft law on the issue and get to the hard law in Trinidad and Tobago. And this principle first found expression in the Organization for Economic Cooperation and Development Council in 1972. I'm not going to read the contents of that because our submission to the court is not detailed, but we see as early as 1972 developed the principle, economic principle really, in order to even defeat in respect of production and not to have some countries be placed in a better position in terms of the cost of manufacturing goods. The principle really became, and that's at EB 17 1977, and it's contained in our submissions. The principle really became very fashionable and more widely accepted as a result of the famous United Nations Conference on Environmental Development in Rio. And it's called the Rio Declaration, which is contained in our bundle as well as EB 1681. And
Sorry,
particularly principles,
would you give that reference again for the Rio Declaration?
it's EB 1781.
Thank you. Thank you.
Principle 16 of the Rio Declaration, my lords, I think I should read it because it's important. It says national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments taking into account the approach that the polluter should in principle bear the cost of pollution and due regard to the public interest without distorted international trade investment. So that principle has a number of components. The first component is that the polluter should bear the cost of production. And secondly, it is of the public interest to do so secondly. And thirdly, if you don't do so, there is a real possibility of distorting international trade, with some countries allowing widespread pollution and others not, and therefore the cost of production in those countries that are engaged in environmental management and control would be much more than other countries that are allowed to pollute. We have an extract in our skeletal submissions at EB 1804 from Moffat and Greger in a very well-known article in environmental law called The Role of Law in the Promotion of Sustainable Development. And that might be useful for us to take a read of because it tells you philosophically what is the heart and soul of this principle, why is it is so important, and why it informs legislation. Now, two principles really arise out of this. And first of all, is that costs must not be externalized to the public. And secondly, cost of production should be internalized as far as possible on the manufacturer or the polluter, as the case may be. That is what we take from the soft law. Take also the principle that the polluter must pay, and therefore, out of that, we have the next bit of soft law, which is important and which is important for this reason, is famous Caribbean Community Treaty. That treaty, my lord, has a protocol 3 of 1998, made 30th of June 1998. Subarticle 3. Subarticle 3 of that protocol provides the precautionary and those principles related to preventative action, rectification of environmental laws, and the principle that polluter pays.
Sorry.
Now, ask my lord specifically.
Sorry. Where were you referring then? I missed that reference. Where was the reference? Which page?
It's set out in our case at electronic bundle 963, my lord. The principle is reproduced there for ease of reference.
Thank you.
Much obliged, my lord. Now, if I were to take that principle and develop it, it is important that we have now brought into the dialogue frontally in this region the principle of rectifying environmental damage at source. Rectification or remediation, we say, is the heart of this case. And it forms, it's the principle of the CARICOM Treaty, and it is a principle that has informed legislation throughout the entire region. Now, we have usefully inserted in as an appendix to our case comparative jurisdictions where this principle has found expression in the United States, in Canada, in Europe, in India, and in several other countries. I don't propose to take my lordships through it. I think it is at EB 961 to 967 of our case. It's all there, but my lords would see that they are.
Could I possibly just interrupt a moment? I was very interested by these references to the comparative versions of the polluter pays principle, and it's something that I've actually made quite a study of. But it seemed to me that this case, we really need to concentrate on Trinidad, because what you've actually got here is a provision in your national policy, which actually is rather ahead of some of the other examples we've seen, because it's very specific. And what your case is really that, given the very specific policy you have in your jurisdiction, the minister hasn't really had regard to that. So although it's very helpful to have the background of these other comparisons, I think, for my part, I'd be quite keen to focus on what's going on in your jurisdiction.
Very well, my lord. We placed that at as an appendix, so as to assist the court in appreciating more fully what is the hard law in our country in respect of it. And perhaps I can get to that almost immediately. And we identify, first of all, our Constitution as, again, in the preamble of our Constitution, EB 10002, as having a provision that deals with the issue of PPP. We mention also the 1995 Environmental Management Act and the 2000 Act, which we see there is no difference, in fact, between them in terms of that preamble that is contained in the 1995 Act and 2000 Act. It says sustainable development should be encouraged through the use of economic and non-economic incentives, and polluters should be held responsible for the cost of their polluting activities. And that's in the preamble to the Environmental Management Act, and that's at EB 1030. 1013, I beg your pardon, 1013. Then we go to Section 4. I think that is important because it leads finally to the policy. Section 4 of our EM Act. And Section 4 deals with the object of the Act, and that's at 1018, EB 1018. And Section 4 of the Environmental Management Act, and it says, develop, effectively maintain written laws, policies, and other programs for and in relation to the conservation and wide use of the environment to provide adequately for meeting the needs of present and future generations and enhancing the quality of life. And 2, the government's commitment to achieve economic growth with sound economic practice, and very importantly, 3, the government's international obligations. So our international obligations, when we are interpreting our policy, has to be interpreted as against the background of the CARICOM policy and the Rio Declaration, to which we are signatories. And those are the objects of the Act, so to speak. And we say that the objects of the Act point in that direction as well. Now, Section 16 of the EM Act deals with the question of the national environmental policy, which I dealt with before. It says part of the statutory function of the minister would be to make, of the authority to make recommendations for national environmental policy. And that's at EB 1023. It says develop and implement policies and programs for effective management and wide use of the environment consistent with the objects of the Act, monitor compliance with the standards, criteria, and programs related to the environment, take all appropriate action for prevention and control of pollution and conservation of the environment. So that takes me straight into the point the Lord inquired into, is what is the hard law on this subject, Trinidad and Tobago. And in that regard, I might come alert to 2 sections in the Environmental Management Act, sections 18, sections 31. Now, Millard see that the authority has to be the national environmental environmental policy under 16.1. Under 16.2, the board, after preparing the national environmental policy, board submits it to the minister, and the minister engages in a process of consultation, um, which is all set out in section 18. And after that is done, and he considers the recommendation, and he considers revisions. Under 18.6, the minister shall, within 1 month of the approval of any policy submitted under section, cause the policy to be laid in Parliament. And that is statutory underpinning, which I referred to previously. So this policy is statutorily underpinned. It's mandated that the authority prepare it, but the person who has the responsibility to lay it in Parliament and who takes paternity of this policy is the minister. As I said before, the first national environmental policy was in Parliament in 1998, and the second was it was subsequently revised in 2005. But paragraph 2.3 remained consistent in both the 1998 version and the 2005 version. That can be found at EB 12.2. In addition to it, at EB 11.06, in February 1917, a draft of the NEP was published and repeats the same point 3, which I read to Malad a short while ago. So the fact is, the minister and the state have been very consistent about the actual circumference and the width and the diameter and breadth of the national environmental policy insofar as it relates to the PPP as the case. The minister in these proceedings, in the agreed facts, has agreed that he has an obligation to comply with the policy, and that is not in dispute. What is in dispute is really the minutiae 2.3 and whether in fact he has complied with it. This policy, of course, having been laid in Parliament, would have attracted the consequences which are referred to in Section 31 of the Act, which is found in the electronic bundle at 10.3. It reads as follows. Section 30. The authority and all other government entities shall conduct their operations and programs in accordance with the national environmental policy established under Section 18. So we give that, my lord, it's plain and ordinary meaning. We say not only is the authority, but we say the minister is bound to follow his or her own policy, as the case may be. Policy in respect of PPP made first in 1998, subsequently made in 2005 in exactly the same, no published exactly the same in 2017. For the minister to fail and or neglect and refuse to follow that policy would give a blank check to the minister not to have regard for any of the contents of the policy and approve matters which are contrary to or ultraviolent policy or inconsistent with the policy, as the case may be. The minister can change the policy. He had an opportunity to do so in 2005, and once more again in 2017. This has an opportunity to do so. But you can't make a policy that is democratically entrenched as this policy is by a process of consultation and laid in Parliament, and then neglect to follow very baseline foundation principles of the PPP, which you have established. We say that the failure to do so is very inconsistent and does not comport with what the policy of the minister is. We say two other things about that policy of 2.3. We say there is absolutely no ambiguity in the language whatsoever. It is plain, it is clear, and it is unequivocal. The second limb is a remediation limb. So when we examine the contents of 2.3, from that the following propositions. First proposition I draw from 2.3 is as follows. There is the key principle of pollution control is the cost of preventing pollution, of minimizing environmental damage. You can prevent it or you can minimize damage. And that cost has to be borne by those who are responsible for the pollution. So those are two cardinal principles, is prevention and minimizing. The second sentence, the 2.3 says, principle seeks to accomplish the optimal allocation of limited resources. So therefore, that brings into play, into the equation or the debate, so to speak, the principle of internalizing the cost of pollution and not externalize it. And then the principle goes on to provide some details, and the definition is not an exclusive definition. It is important elements of the principle are. So it's not an exhaustive statement of what those principles are. It says charges are levied as an application of processing fee, purchase price of a license or permit, which is entitled to generate specific quantities of pollutants. So the first limb of that deals with the charges levied on the application of permitting fee, and that we say has been accomplished by the 2001 regulations, fees regulations, 2006 regulations. All is well and good with that. Now, what is conceded by the state in the affidavit of Mr. Cotter is that the fees charged, the $10,000 fixed fee, is a fee that covers the processing of the application and the administrative fees. It does not cover remediation fees as the case may be. Therefore, only the first limb of the principle is fulfilled. Second stage, Millards, is monies collected will be used to correct environmental damage. So, it is implicit in that the fact that the following facts. First of all, if you are charged a permitting fee, it might still be environmental damage because your environmental load might not be reduced to a position where you ought not to get a permit as the case may be. And it is that latter aspect where the money is collected to be used to correct environmental damage, the remediation aspect of it, that is not covered by the fees program as the case may be. I will deal with that a little bit in more detail.
May I ask, how far does it go? This paragraph says that the cost of preventing pollution or of minimizing environmental damage due to pollution will be borne by those responsible. And it says money collected will be used to correct environmental damage. So it doesn't say that the whole of the cost must be borne by the polluter, does it? It says that it's sufficient if the cost of minimizing environmental damage is borne, and it says simply that some of the money collected at least will be used to correct environmental damage. So there's a pretty large discretion, am I right?
Lord, I don't think so. I mean, my respectful submission, I disagree with that for the following reasons. And perhaps I can back up a bit and make some submissions of how it is that it operates in principle. The first thing, my Lord, is that in order, if you have crossed a certain threshold in terms of the release of pollutants into the receiving environment, what you do is that you have to obtain a permit. And in that regard, might I refer to the rules at Electronic Bundle 1074. And 1074, the relevant part begins at 1075. It says permissible level. 1075, permissible level means the level specified in the second schedule, outside of which a person releasing a water pollutant may be required by the authority to submit an application pursuant to Rule 8 for a permit. So therefore, if you go outside the permitted level, what you ought to do is now you apply for a permit under Rule 8. Now, when you receive this permit, what happens is that permit is granted to you subject to conditions. So conditions are specified in 15.4, which is found at Electronic Bundle 1085. In determining the conditions of a permit, the factors to be considered by the authority shall include, but not be limited to, the industrial profile of the activities conducted in the facility. For example, if you do an oil refinery as against a shop that repairs cars, the volumetric release rates, effluents, quality of the effluent, including conditions and concentrations of constituents, characteristics of receiving waters, age of the facility, etc. So these conditions are placed on your permit, and these conditions serve to minimize, not necessarily eliminate, to minimize. And in some cases, if it eliminates the pollution altogether, you apply under Section 17, that is the Electronic Bundle 1086. And you apply a variation because the conditions which have been imposed upon you has not been satisfied and there is no need for a permit any longer. Now, there is a spectrum where you are in receipt of a, but then yet you continue to pollute the environment, notwithstanding the fact that you have minimized your pollution, but you have not prevented it, you have merely minimized it. And therefore, the receiving environment continues to receive, at least for some years, and perhaps more, receive pollutants as a consequence of activity. That is the classic case of the externalization of pollutants and not internalization consequent upon the grant of a permit. Issue then arises as to what is it that it provides for, what is it policy provides for in kind of environment. And perhaps I can take my Lord Mans and return you to 2.3 of the NEP, because in Electronic Bundle EB 1213.
Yes. 1213.
In that scenario, my Lord, 0.3 of the NEP, that's in our, it's 1213. In that scenario, what you have is the minimization of environmental damage. Alternatively, you have a prevention of pollution. If you have a prevention of pollution, Rule 17 kicks in, and you're no longer required to have a permit. If you have a minimization, you bear the cost, of course, by following the conditions or complying with the conditions set by the authority. But you still have a pollution profile, respect quantitatively and qualitatively in respect of the matters referred to in 15.4 of the rules, which is really externalized cost, which impacts on the environment and affects the public. So it is in that situation that the public and the environment is affected, and there's need for remediation, not necessarily in respect of that site, but generally. If we think in terms of, let's say, 100 persons who are permittees, minimizing their pollution profile, but not preventing it altogether, the accumulation of that results in an accumulation of pollution in the environment. The monies collected ought to reflect the cost of remediation. Now, to answer Milord's question directly, the respondent to this matter has admitted that the cost of the permit, namely $10,000, that is fixed irrespective of the profile of the pollutant, is spent in terms of processing the pollutants. It's a process and administrative cost. And therefore, there is no cost attributed to that in terms of the B part of 2.3. And that remains, that expectation or that policy remains unfulfilled. It's not satisfied because of that fact.
Could I just interrupt there a moment? I think we've got to be clear what we're talking about. There are conditions on the permit which ensure that the operator keeps within the requirements and uses best practices, and also the conditions require him have a duty to mitigate if something goes wrong. But that seems to me is probably different from what we're talking about here under the B of the polluter pays principle, which is what's happening to money collected by the authority. And what it's saying is that money collected from permits will be used to correct environmental damage. Now, what that seemed to suggest to me was that the authority is building up a fund from which it can intervene and correct damage itself. It's not talking about the operator's own duty to correct his own damage. It's talking about something on top of that. Is that the right understanding, or how do you see it?
Well, that takes me to the establishment of the financial workings of the authority, which is contained in sections 74, which is the 1052.
1052. Right.
Beginning of 1051 at section 72.
Yeah.
Now, my lords, if we look here at under part 7, we see how the finances of the environmental management authority is set up. They set up an environmental trust fund, and into that fund goes all of the fees that they collect and all of the fines and all of that goes in there. Now, there's an obligation on them to intervene at 72.C for emergency response activities to address actual or potential threats to human health or the environment, including remediation or restoration of environmentally degraded sites. And that is the mandate which they have in terms of remediation. Remediation is also dealt with.
I think we need to look at 73B, 73.2b, which go into the fund, go the amounts collected for fees due regarding permits and so on. So that's the point you made.
Which page?
1052, section.
Yes, that's right, my lord.
74.
2b.
74B.
74, sorry, 74b.
Yeah.
Yes.
74B, that's right, my lord.
So there you
That's
get,
correct. What happens is that.
so that
Beg your pardon.
supports your point that part of the purpose of the permit fees is to feed into the fund and finance remedial measures. Yes, sir.
Yeah.
But, my lord, the problem in this case is that all of the funds that are, all the permitting fees are paid into the fund. And the cost, the $10,000 covers absolutely only the permitting fee. That is the cost of processing the permit, and that is admitted. That is admitted by the respondents. So what you have is really, again, the example of a motor vehicle repair shop or a shop that is involved in a refinery. They pay $10,000, it goes into the fund, and that is used to process the conditions for minimizing or preventing pollution. But there's still a residue of pollution that is above what is generally desirable and above what is contained in the second schedule. So how do you deal with that? If all the monies that you collect are used exclusively for purposes of processing the conditions and studying the environment and seeing what conditions to impose, what minimizing conditions to impose, none of it is going to be available to do remedial work under 72C, as the case may be.
Yes, well, I think we've got that point, at least I've got that point, but the answer, I think, that Mr. Rowe makes to that is it is his paragraph 43 of his case at electronic bundle page 984. He says, as I understand it, they're collecting fees which are actually financing the activities of the authority. And as one of the activities of the authority is ensuring remediation, then in a general way it is doing what it's supposed to be doing. Have you seen that, his paragraph 43?
Yes, my lord. Yes.
What's your answer to that?
Well, my answer to that is really found in 2.3, my lords. Because 2.3 places, there are two mandates on the authority. The first mandate is to charges are levied on an application of processing fee, but there's also a mandate for remediation. Now, if all the fees that are charged are used for processing the applications, therefore none is going to be available to fulfill the second mandate of remediation, which is found in several paragraphs of the several sections of the Act, as well as in several parts of the National Environmental Policy, as well as the program. So all the monies are going to be spent in processing the permits, and none is going to be available for purposes of remediation. And the mandate we say under 2.3 is a specific mandate in respect of remediation, not in respect of processing the applications.
Yes. Well, I think Lord Hughes has got a question.
Could you show us, please, the best...
But could I just...
No,
sorry.
wait.
Could I just...
wait.
Just adjust one further point here? Sorry.
Could you show us, please, the best place, from your point of view, where it is said that all the license fee money goes on administration of the license system only and not on sections 72 and 73 and 74 of the Act?
Well, if we look at electronic bundle at page 268.
268?
268.
Yeah.
I deny those parts of paragraphs 36 and 46 of the first and second abode affidavits, respectively, which allege that the water pollution fees amendment regulations are contrary to the PPP. As deposed to above, the permit fees are authorized by the Act and prescribed by the water pollution rules. The permit fees are intended to cover the cost of administering the management of water pollution and include the PPP.
Lord Wilson.
They stand as one standard fee.
Lord Wilson also has a question.
Mr. Hussain, I wondered whether
And
you...
paragraph 10 as well, my Lord, if I may. Lord Hughes, paragraph 10 as well deals with that. My Lord Hughes.
Mr. Hussain, I think you've just dealt with my point. I was wondering whether, in answer to Lord Hughes, you would want to point to another part of this affidavit of Mr. Goddard, namely in paragraph 10, from lines 8 to 15, roughly, where he says that the fees payable are intended to make the programme self-sufficient and sustainable, and for that purpose to recover the cost of operating the programme from those who discharge pollutants.
That is right, my lord.
Very well.
And I think also, Mr. Hussain, in fact, paragraph 43 of Mr. Rowe's case, the respondent's written case, effectively accepts the same point.
Yes, my lord, that is correct.
But it goes on to raise a justification by reference to the permit conditions. It suggests that they effectively reduce pollution to nothing, as I read it. But we have only seen one permit, at least I have only seen one permit, and I did not see any conditions in it. Do we have relevant conditions? Perhaps I have missed them.
Well, the conditions that might be imposed are dealt with in the rules, and this is not an example of a permit, but it's an example of what.
Can we look at page 274, after Mr. Goddard's affidavit? We have an example of a permit. And then on page 276, as I understand it, we have the conditions and limitations.
Good, yes.
And they deal with all sorts of detailed matters, including
Yes, I see. Yes, I'm with it.
on page 290, a duty to mitigate, and so on.
Yes.
They do.
So that
The permit does include conditions which require the operator to reduce and remediate damage. But what I think Hughes says, well, that's not using the monies collected from the fees. That's a different thing. That's a duty on the owner, operator. It's not using the fees actually collected from the permits.
yes. Now, I accept that, my lord. My lord, in addition to which, the fact that the authority imposes conditions that are intended to minimize the pollution load released into the environment does not mean that the elimination of pollution will take place, because if it does, they can apply under Rule 17 for a variation to eliminate the need for a permit. That's the first thing. And the second thing is that in any event, if they don't do so, once they cross the permissible level that is defined by the rules, and the permissible level, of course, is set out in Electronic Model 1075, and it's set out in more detail on the schedule of the rules. It's set out at Electronic Bundle 1093. At 1093, what we have is the second schedule, the permissible level. So, theoretically, what we have is as follows. We have a permittee who exceeds these levels. He has to make an application for a permit. He's granted a permit. Conditions are imposed to minimize the release of pollutants into the receiving environment. The release of these pollutants are minimized, but they are not eliminated. But at the same time, they are in excess of the permissible levels spelled out in the second schedule, either for a few years or a longer period, as the case may be. The issue is that when you multiply that many times over, that goes on remedy, and what happens is costs are externalized. Some of it is internalized as a consequence of the conditions imposed on the permit, but you are still exceeding the permissible level set out in the second schedule. And that scenario, we say that the second limb of 2.3 is engaged, and engaged to the point where you have to pay something additional to that of processing the permits, the administrative costs involved in processing the. What you have to do is to give the authority sufficient leeway to be able to do remedial work. Now, my lords, if I may, in section 74 of the legislation, section 74 deals with the ability of the authority to use the fund and to segregate the fund into different areas. 78, I beg your pardon, at electronic bundle 1053. It reads as follows. Contributions to the fund may be designated for specific projects or may subject to specific conditions, in which case such contributions shall be preserved and utilized solely for designated purpose. In all other instances, the trustees are authorized to pay for any of the following matters out of general resources of the fund. So the fund deals with operating expenditure, capital expenses, any payment towards the purchase of real property, and other expenses. But there's also a directive on the part of the authority to remediate the consequence of, first of all, emergency remediation dealt with in section 72 of the Act, as well as in section 25 of the Act. So, as a result of that, if all the fees are spent in the permitting or administrative process, there are no funds that are available to establish special funds for dealing with non-operating and capital expenditure and any remediation. So the second limb of 2.3 remains satisfied.
Right, thank you. Now, Mr. Hussain, that is really the heart of your case, is it not?
That is the heart of my case, Mel.
Yes.
My lords, could I just, I think I have a little time extra, so if you.
Yes. Do you want, I mean, we're not cutting you short, but do you want to say anything more to develop that point, or with reference to the Court of Appeal judgment, for example?
Yes, I could perhaps talk about the Court of Appeals judgment and make a few comments about it.
Can I just put one other point too? Can I just put one other point? Your case is essentially that at any rate in 2005/6, the polluter pays principle should have been considered, especially in the light of the authorities' recommendation, and it wasn't, at least there's no evidence that it wasn't, or if it was, it's certainly not complied with. Have I understood that?
Yeah, well, more than the authorities' recommendations, it also has to do with the policy which was laid in Parliament.
Of course.
So therefore, in the hierarchy of things, the statutorily underpinned policy. But my lord,
of course, yes.
I'll put your finger on another issue which I think can reinforce this point, and it's really the water pollution program, which is really the authorities' policy on water. And perhaps I can just touch that because of the fact that Section 52 of the Environmental Management Act says to the authority, you must develop a program to deal with the management of water pollution. So this water pollution program was developed. It does not have to be laid in Parliament, so it does not have the status of the policy. It's a program. It was developed in February 2006. And as a result of that program, they undertook an analysis of how they should approach the question of permitting, dealt with in the rules and referred to in my previous submissions. Electronic bundle 1288 deals with that. And if I could just take you there. It deals with this, with what is contained in the program. Yeah, 1288. So at 1288, you have 6.4.281 introduction, and it deals specifically with water. And if I can just refer you to that very briefly, research has revealed that the use of several mechanisms to calculate permitting fees with respect to the discharge of liquid effluents. Speak of the United States and then Trinidad and Tobago. In terms of the needs of Trinidad and Tobago, certain basic parameters are established, and these are as follows. System should be relatively simple and easy to administer. 2, the permitting system should generate adequate revenue to cover the cost of the permit program. So far, so good. It should be equitable both in terms of ability to pay and actual levels of pollution. That, in my respectful submission, has been violated, and it supports the polluter pay principle as contained in the policy. And 4, permitting fees should not only reflect the cost of granting the permit, but also the impact on the environment. And that is the issue that we take issue with that as well. That has not been satisfied. Basically, there should be consideration of the polluter pay principle, so as to achieve ultimately a more responsible attitude toward the discharge of effluent. Now, what the authority subsequently did in 2005, and I asked Malot to note that this was before 2006, where Minister Beckles did her regulation. It was after the regulations of 2001 and before the regulations of 2006. And this is an authority's document. It is not a ministerial document. What took place there was the authority examined several models, and the first model they established at 6.4 at the bottom is the actual cost model. That was not recommended. Second model is the egalitarian model, and this is the model which was used by the minister. And this is what it says. The model suggests an identification of the total permitting costs on a yearly basis and an estimate of the number of permits that the EMA anticipates will be issued. The total permitting cost is divided by anticipated number of permits, resulting deemed to be the permitting cost. So here again, you had mentioned the issue of how do you deal with the issue of permitting costs. And what it is a strict arithmetical approach whereby you estimate the amount of permits that you applied for, estimate your the cost of running this exercise, and you divide it, and you get a permitting fee of $10,000. This is a simple model that is quite easy to administer, but it suffers from several inherent deficiencies, such as the failure to distinguish between ability to pay, lack of consideration of pollution profile, and impact of pollutant on the environment. So this is the egalitarian approach that was used in 2001 regulation.
Yes. Well,
more importantly, in the 2006 regulations, which is available.
Mr. Hussain, you've set out this point very clearly in your written case, I think, and I think we understand the point. How does it link? You say it's an additional supporting point. Is there any evidence as to ministerial consideration of this program? Do we have any evidence about the decision-making process which led to the fees being refixed at the same level, flat fees, in 2006?
My Lord, there are two things. First of all, there was no evidence at all in respect of how the 2006 fee was fixed, because the minister did not give any evidence as to that, nor did anyone from the ministry, as the case may be. And that is the first point. The second point is that when the minister was asked in the pre-action protocol exchanges as to why is it that the fixed fee was repeated in 2006, the minister mentions the fact that she has referred that to the authority for an answer. Now, our submission to that is not a matter for the authority, because the authority is an independent body charged with the responsibility of regulating environmental matters, even prosecuting matters and granting CCs and permits. And therefore, that is a matter for the minister. The minister had to justify it, and the minister did not bring the evidence at all to justify that. In fact, on the contrary, if we look at this program, what the EMA did was the Environmental Management Authority actually recommended after it examined the 1291 of the analysis, all the various models, it actually showed that the egalitarian model at 1291 was ranked lowest at 47 points, and the pollution load model was ranked number 92. And what the EMA did is the EMA recommended that the pollution load model be utilized. And what the minister did is contrary. The minister defiance of her policy in 2000.
Lord Wilson has a question.
Can I just ask you to elaborate a point you made 2 minutes ago by reference to Minister Beckle's letter of 16 April 2007, which we have at page 154, Mr. Hussain. In this letter...
Now, if I could just refer you to that letter, my lords.
Yes, can I finish?
This is the pre-action protocol exchange.
Can I finish my question, Mr. Hussain?
Apologies.
That's okay. This is a letter from the minister to one of your juniors. It's clear that your side was asking the minister at number 1 for the reasons for using a flat fee, fixed fee structure for the annual permit. And I think your answer was to refer us to the 3rd paragraph on the 2nd page of the letter, where the minister says, as regards your first request, same has been forwarded to the EMA for comment. And Mr. Hussain, I think I heard you say that that was a surprising answer because it should have been for the minister to give the reasons for using the structure, whereas she refers it to the authority and indeed adds that the authority has requested your side to give further and better particulars of the request to answer a question, quote, what is the comparator for the flat fee, which you might say was not an apt question in order to answer the question which your junior had asked. Have I understood the point you were making about this letter reasonably well?
Yes, my lord, you have put it even better than I could because we say this in addition to what you have said. We say first of all, it is the decision of the minister and not a decision of the authority. That's number 1. Number 2, the authority is an independent body, and in any event, the authority recommended in the program, the authority recommended another the pollution load model and not the egalitarian model. in respect of what should be done. And that is,
Mr.
is,
Hussain, could I just follow up the
Yeah.
question, because I think you're going on to a different point slightly. The exchange that we just seen was actually followed in 2008 by a pre-action protocol letter from your side on page EB 170. That was dated August the 21st, 2008. And that sort of summarized the case you were making. And in particular, on page 174, paragraph 16, it referred to the water pollution program. And the response to that was on page 181 from the then Minister, Emily Gaynor-Dick Ford, saying again, having reviewed the concerns, I've requested that the Environmental Management Authority assess the issues involved so that we can prepare an appropriate response. So again, we have it being referred to the EMA. But as far as I know, and please correct me if I'm wrong, there wasn't actually any further response to that letter. Is that right?
no, my lord.
Until we get the
There's been no
affidavits
response.
in this case. I mean, the following year, in September 2009, we get Mr. Goddard's affidavit in this case, and we get the affidavit from a minister, but he happened to be the minister who left office in 2000. So we've never had an up-to-date statement by the current minister of what their policy was. Is that right?
That's correct, my lord. The minister who saw the affidavit demitted office in 2000. That is Minister Mohammed. And he was not there when the 2001 regulations were made. He was not there when the 2006 regulations were made. There's no record, no written record in producing evidence by Mr. Goddard or the respondent in this matter explaining the chain of responsibility of decision-making in respect of the minister. What we have is an informal, apparently directive, so it is alleged, where Minister Mohammed, who demitted office in 2000, before the making of these regulations, either in 2001 or 2006, indicated to Mr. Dr. McIntosh, the CEO of the authority, what he thought there should be. And at that time, there was no modeling either. So the submissions are as follows. Number one, you cannot rely on a very informal statement made before the making of the regulations in 2001 and 2006 to indicate why is it you are deviating from the policy. Number two, when Minister Mohammed demitted office in 2000, there was no program setting on the modeling, so whatever he may have referred to in his affidavit is simply not accepted. Number three, in any event, the EMA themselves did not recommend this model. So if Mr. Goddard says when he swore his affidavit that and seeks to justify this present model, he is at variance with the position taken by his own department. Number four, the authority and the minister should be separated, and there is no Kaltuna-like delegation. They are separate entities, and the minister has to exercise an independent discretion on independent decision-making process. And fifth, finally, he must follow his policy, and not that of the authority. In any event, the authority could not help him.
Right.
No.
Well,
Unless my lords.
yes, sorry, you were going to say?
Lord, I was about to address the question you asked me more than half an hour ago. That is how the Court of Appeal approached the issue. But if you think you are satisfied with what I've said so far, I can end my submission to you and allow my little friend, Mr. Rowe, to go on. But I can touch very briefly on where I think the Court of Appeal fell into error.
Well, we can't be satisfied, but he can come back on the Court of Appeal in reply if necessary.
Mr. Hussain, you can probably deal with that in reply. if it proves material, unless, I mean, it's up to you. You haven't used up anything like your time. You've been very economical, but I think we can see very clearly what your case is, and for our part, we don't need to have you develop it further at this stage, but it's up to you.
There's one other point I can probably touch on before I go on. That is the learned friend, Mr. Rue, relies on the case of Stanley. That's a case of the European courts, and he relies on it within the context of that particular framework, and perhaps I can just touch on it now. And that's found in the Electronic Bundle 1607. The relevant parts.
Yes?
An examination of Article 130R and 2 would identify the particular article which was the subject matter of this interpretation. We say that, of course, it is country specific, and this provision in Article 130R2 does not contain the second limb of our policy, and therefore when the Advocate General said what he did, cited by my very learned friend Mr. Rue at paragraph 95, he did not have to deal with the second limb of 2.3 of our policy, and therefore this case is unhelpful in respect of how the matter should be approached, because we have gone a little bit further. And the final point I wish to make is the fact that, and I will get the relevant parts from the electronic bundle, the issue of remediation is dealt with not only in the Act. The issue of the obligation of the EMA to remediate is dealt with as well in the policy, and is also dealt with in the regulations. And I don't have it immediately at hand, but I can in my reply direct you to the relevant parts. Where remediation is, as contained in 2.3b, is an integral and recognized part of the law of Trinidad and Tobago, which has to be factored into the calculation of.
Could you just take that more,
and that is,
could you take that more slowly, because I didn't pick up what you were talking about there. We're talking about mitigation, are we? Have I missed it?
remediation, Millet. Remediation.
Yes.
Remediation.
And what was the reference you gave us?
I would provide it in my reply, my lord, but it's there in the regulations and the rules as the case may be. And more particularly in the program. The program, which is from the EMA, the program stipulates a requirement of remediation, and perhaps I can just point you to it now whilst we're at it. If we look at yes, if we look at electronic bundle 1223 and 1272 and 1034, and our paragraph 89 of our skeletal arguments at page 959. And this is what we said in our submissions. This is significant as the fund is what is to be used by the authority undertaking any correction of pollution damage, either under its general powers or expressly provided for under sections 25, 35, 34.1, and 72 of the EM Act. So those are the sections that deals with the question of the correction of pollution damage. 25, 34.1, and 72 mediation. And the National Environmental Policy at 3.7, Electronic Bundle 1223, deals with remediation, and the program that is promulgated by the authority at 6.3, Electronic Bundle 1272, also speak to remediation of bodies of water whose existing quality is less than the specified quality. So remediation is integral to the legal landscape and finds hard law expression in the Act and soft law, almost soft law expression in the policy and the program. So in the context of interpreting 2.3b, has to be interpreted in the context of what the Act gives the authority to do. What is the policy, the minister, and what is the program of the EMA, all of which have been statutorily enabled in the case of policy laid in Parliament on 31, and in the case of the program made by the authority pursuant to a statutory mandate under Section 2, I believe. Now, Millard, there's one other issue, and this is not a case as in Tesco, where there are conflicts in terms internally within the policy. This is not, of course, a hard. The learned friend uses the word. Of course, it's a policy that is laid in Parliament, but there's no ambiguity. There's no room for conflict, as in Tesco. It's a freestanding right under the policy in which, respect of which we do not have to establish an expectation in mandate. And therefore, difficulties of implementing this are not such where the minister would have to exercise a discretion within the framework on conflict or ambiguity. The provision of 2.3 is clear and unequivocal, and the mandate, when looked at in the context legislative structure, is very clear indeed. So TESCO, my respectful submission, does not apply, and Mandelia is on all fours in terms of the fact that the policy in itself creates a freestanding right, the enforcement of which is integral to the environmental integrity of the state.
Thank you very much indeed, Mr. Hussain. I will call formally on your junior, Mr. Das, whether he wishes to add anything.
No, thank you, my lord.
Thank you very much indeed. Then I'll call on Mr. Rowe to respond. Yes.
My Lord, although I appreciate your Lordships will have already taken some time to look at the statutory material.
Can you hear Mr. Hussain?
Yes, I can, my lord.
Right.
My Lord, I'd like all the same, if I might, to take your Lordships through the statutory and regulatory structure one more time, I hope fairly briefly. Because in my submission, this is one of those cases where once one grasps that, it is rather more clear what the answer ought to be. Can I start with the Environmental Management Act itself, which is in Authorities 1, tab 2. And the provision that my learned friend understandably puts at the heart of his case is section 31. That, your Lordships will recall, is the section that says that the authority and all other governmental entities shall conduct their operations and programmes in accordance with the national environmental policy established under section 18. And we accept, at least for the purposes of this appeal, and this was accepted in the courts below, that expression is wide enough to cover, that's to say, operations and programmes being conducted in accordance with the policy is wide enough to cover legislating under the National Environmental Act for such things as the rules about water pollution. and what the fees should be for those rules, under those rules. That therefore calls attention to the policy itself, in accordance with which the executive has to act. And can I just take your lordships to the policy and go to some provisions which are a little wider perhaps than so far has been the focus of attention. The policy is behind tab 9, page 1202. And I emphasise, of course, at the outset, for reasons that will be obvious to your lordships, that it is a national environmental policy. It is not the National Environmental Statute or the National Environmental Regulations or rules or whatever, or guidelines. It's policy.
But I mean, unusually, for a policy, you don't just have to have regard to it, you have to act in accordance with it.
In accordance with it, yes. I accept that, my lord. Can I then take your lordships within the policy, first of all, to page 1204, which is described as the foreword, but given where it's put, appears, at least to some extent, to be itself a part of the policy. And we can see on that page, 1204, that the author of the foreword, who's not accredited, but presumably is somebody who speaks with the authority of the person who made the policy, or the body that made the policy, says that the National Environmental Policy, this is about 3 paragraphs up from the bottom, is aimed at providing a rational, practical and comprehensive framework for environmental management. And it goes on to say at the end, the more detailed procedures and concrete actions which will be required at sectoral levels to achieve effective environmental management will therefore find their bases in the principles and broader approaches embodied in this national environmental policy. And I emphasize those words because they fit in with my and support, I submit, my overall submission as to the way in which this policy falls to be construed when one is then considering later on whether or not there has been action in accordance with it by the government. Can I then turn to ask your lordships to turn to 1211? And it's in this section, of course, that we find the words upon which my learned friend understandably places the greatest weight, and which has already been the subject of some discussion in the course of the hearing. But it's important to set that in context as well. This is in Chapter 2, entitled Goals, Objectives and Basic Principles. And you can see that there are goals at 2.1, objectives at 2.2, and basic principles at 2.3. And the wording underneath basic principles is important. Government's environmental policy will be guided by the following basic principles. So although I had to accept earlier on that the statute itself requires the government to act in accordance with the policy itself operates at a number of different levels, and at this stage we can see that what follows this introduction, these initial words of 2.3, are principles by which the government's environmental policy is to be guided, and that, in my submission, is quite important when one comes on to consider the application of the specifics that follow. One of the basic principles by which the government's environmental policy is therefore required to be guided is the polluter pays principle, as it is described at 1213. And even here in my submission, the language is somewhat open-textured. The draftsman starts by asserting that a key principle of pollution control policy is that the cost of preventing pollution or of minimizing environmental damage due to pollution will be borne by those responsible for pollution. It describes what the principle is seeking to accomplish. And then the next words, I say, are also important. Important elements of the principle are. And then it lists the two things that we've looked at, charges being levied, and my friend perfectly understandably and rightly emphasizes the word and, money collected will be used to correct environmental damage. There's a little more which is relevant in the policy to this case, and that's at 1222. This is in the chapter entitled Conservation of Natural Resources, Chapter 3. And we can see 3.7 deals with water resources, government will, in the middle of the page, and then a long series of things that the government will do. And if we follow it through over the page to 1223, we can see at letter I, government will control water pollution through a system of permits for facilities that are the sources of any release of water pollutants. This control system will be based on the polluter pays principle, which will set pollution limits or performance standards for water. The cost of pollution prevention or of minimizing environmental damage due to pollution will be borne by those responsible for pollution. Now, my Lords, although it may well be that your Lordship's decision ultimately will focus on the words in 2.3 that my learned friend places most emphasis on, it is important in my submission to recognise, as it were, in the background, that the polluter pays principle is a rather broad and open-texted principle, which is open to interpretation in a number of different ways. And I've picked up in our contribution to the materials on this subject a couple of references, which I'd like to take your Lordship to, if I may, very briefly, although these are mentioned in our case. They're in Authorities Bundle 3. The first one's at tab 29, and it's from a text on environmental law, this chapter of which has been written by Neil Parkworth and Gordon Nardell, Queen's Counsel. The bit I refer to in the case is at 1793. This is all behind tab 29, but probably in fairness I should also invite your Lordships to look at 1292, where the authors set out in the middle of that page under 2118 what they say the polluter pays principle is designed to do.
So you said... Sorry, you mean...
1792.
Did I say something different? 1792.
Yes. Yep.
You say this is written by QC?
That's what you pick up from 1790. It's one of these books, although it's Bernard Hall Environmental Law with various editors, it's actually, the work of actually writing it is farmed out to various different people. Yeah. And I think this is chapter 2, yes, 2118, which is why it's known to be by them.
This is Neil Papworth and Gordon Nardell. Yeah.
Yes.
Okay. Right.
And it's right to say that they assert the polluter pays principle is designed to ensure that the full costs of environmental damage caused by polluting activities are borne exclusively by the polluter. They set out the background to that there. But over the page, they comment under the heading imprecise content on the difficulty in working out in a particular case exactly what the polluter pays principle means. I can just invite your Lordships to read that passage, if I may.
Right.
You'll see they raise various questions for what should they be made to pay, how much should they be made to pay, and so on, as they say. Those are precisely the sort of questions which arise as a matter of policy if one has first determined that one's going to apply the polluter pays principle. And my submission, as your Lordships have anticipated, is that in this case, the policy decision that has been taken is just that, and it's therefore, well, I don't say it's not justiciable, it's a decision which ought to be treated with some caution if it is said that the court should come in and say that it's contrary to policy.
You're going to come to it, I'm sure, but it depends upon the assumption, your submission, that somebody did focus on the polluter pays principle. And we have very little evidence that anyone focused on at the relevant time.
Well, I'll try and develop this in a bit more detail, perhaps after the short adjournment, but in broad terms, I'm not sure I do accept that that is the way it ought to be looked at. This is essentially a challenge to a piece of subsidiary legislation. It's a challenge put principally on the basis that it's inconsistent with the national environmental policy. And that's really the challenge that we seek to meet. It's right to say that the decision in 2006 to reinstate the fee schedule in the way that was done, with some alterations, but not to the fee of $10,000 per permit, wasn't the subject of any evidence explaining how it had come about. I accept that. But as I shall seek to demonstrate, in fact, the challenge is really, when one looks at it properly, a challenge not to a decision that was taken in 2006, but to the very structure of the scheme itself. And I submit that actually the principle of the flat fee being payable for a permit is not something which is contained in fees regulations. It's not the product of a decision either in 2001 or 2006. It's actually inherent in the rules themselves.
Yes. I understand this, but I think there's a separate and important point is what actually the policy means.
Yes.
Because on one view, it's fairly specific, in fact, more specific than any similar policy that I've seen around the world, in that it talks about fees collected or being used specifically for this purpose. Now, you seem to be saying, well, we should read it in the light of the sort of general woolliness of polluter pays policies as illustrated by Bernard Hall. But is that the right way? Shouldn't we
well, it depends which
meaning of the words actually used by the NEP itself?
It depends, my lord, upon which bit of the appellant's attack you're considering. I agree. When it comes to the narrow focus on 2.3, you've got to look at what 2.3 means. But even in that context, I say there is room for some judgment as to what it means. And I'll come on to develop this, but there's a distinction, I will say, between the question of what a policy means, which is a matter of law for the court and not for the minister to make his or her own mind up, subject only to irrationality challenges and so on, and the question of how you should implement a policy when it allows some scope for judgment as to how it should be implemented. But it's fair to say that the material I'm asking you to look at the moment is more relevant to the general proposition that this.
Well, surely it goes to interpretation. I thought you were putting it forward as relevant to interpretation, that we shouldn't take the wording of this particular pollution pays policy too seriously, because pollution pays policies are notoriously vague.
Yes,
that's a fair way of looking at it.
I wouldn't say one shouldn't take it seriously, but it's clearly a relevant part of the context that, in general terms, the polluter pays principle is capable of a number of different interpretations.
But we're concerned with this particular.
Of course. No, entirely, and I accept that when we get on to looking at 2.3 second limb, which seems to be now the real focus of Malone Friend's attack, one does need to look at that and see what it means in context. But I don't reserve from the fact. I still say even in that context, it's relevant to look at the fact that the polluter pays principle is a broad principle, capable of different interpretations. That informs even the consideration of the specific wording of 2.3 in my submission. I'd taken ownership, I think, to 29, just very briefly, just to complete this part of the submission. 30 is on page 1796 is another extract from a text. And this is 1796 in the box, the polluter pays principle, but over the page is what I really had in mind. 1797. Like other environmental principles, the PPP, this is the last paragraph in that box, is essentially a guide to desirable courses of action. They say it's fairly clear it's rarely been fully satisfied in either EU or UK environmental legislation. As a result, the principle has sometimes seemed to be all things to all people. And they go on to say it's been used to justify views with which it has little connection. My Lord, the other reference I had in relation to the general breadth of the polluter pays principle was the Stanley case, but Malone Friend's already taken your lordship to that. For your note, it's the one at Authorities 2, tab 17, page 1591. I don't think I need to go back through that, and the relevant passages are set out in our case in any event. But it's striking, perhaps, in that case, that certainly the general polluter pays principle, at least in the opinion of Advocate General Leger, was to the effect that it could even be used to describe the fact that you have to pay tax when you fill your car with petrol. In that sense, you are paying for, in some way, the cost of pollution.
Mr. Rowe, I noticed, I was just looking at the documents we looked at earlier, pre-action exchanges. The criticism made there was of failure not just to apply the polluter pays principle, but failure to consider it. And that's why questions were asked which we've seen the answer to, namely that the minister couldn't give the answer, but the authority, it was hoped, would, and didn't. So, I mean, it does seem to me that there is a double-barrelled weapon pointing in your direction.
Yes. Well, my lord, I mean, I quite accept one reads the correspondence and one accepts there isn't any very satisfactory reply to those questions at that stage. But what I shall seek to demonstrate is that, in fact, because this is actually properly understood an attack on the 2001 rules, there is actually some evidence as to how the policy that's inherent in those rules was arrived at, and to that extent there is some explanation as to why. As to what it was, and I submit is an explanation which is consistent with the polluter pays principle as adumbrated in the policy.
But you will, I mean, the thing I searched for without any success was to find what had happened to the water programme, because we see the evidence that it was being developed over quite a long period, and indeed some of it was being done in 1999-2000. But the actual policy is promulgated, as I understand, in February 2005, and is then available, I would have thought, and would be something which had to be considered. But I couldn't find any evidence as to what consideration was given to that by the ministry after it was promulgated in February 2005.
Well, I think it's right to say, and I'm sure my learned friend will tell me if I've got this wrong, that actually, I think he confirmed this earlier, the terms of the policy have remained consistent.
No, the programme.
Relevantly.
Programme.
The programme.
Water programme, which is produced, we're told, issued, or whatever the word is, in February 2005. And one would have expected there to be some sort of evidence of consideration of it by someone, because it clearly has material relevant to how you set the fees, and indeed includes a recommendation. And yet there's no evidence that anyone, certainly no minister, considered it.
I agree it contains, I'll come on to it, I agree it contains a recommendation. It's a recommendation, I would say, in somewhat tentative terms. It describes it as a completely subjective opinion. But I agree there isn't any evidence in the case, so far as I can see, like Your Lordship, which directly shows that consideration was given to that policy at that time. But I do revert to my original point, which is that in substance, and I'll develop this if I can in a moment, this is an attack on the water pollution rules, the scheme that it sets up.
You said that, but we're now looking at slightly different.
Well, I appreciate that, but
I mean, maybe the answer is there isn't anything. And
no, but
I looked at paragraph 15 of your case because I was searching for this, and you refer correctly to what the minister said in 2000, or what Minister Mohammed said about what he had thought about it 2000. Paragraph 15, the respondent, who is a minister currently responsible for environmental matters, takes the same view. And I searched anxiously for some evidence to support that proposition.
No,
unless you're telling me on instructions, but that'd be a slightly odd way of doing it.
Well, essentially, that is the position. I mean, that's why I repeat the point.
We just have to infer that.
Are you simply saying that it follows from the fact that they've adopted the same or preserved the same structure?
Essentially, my lord, yes. This
is not very satisfactory, this paragraph, is it? I mean, one's tempted to reply, how surprising. I mean, in the context of the middle of litigation, to find in counsel's written case an evidential statement of this nature, it doesn't seem to me to carry matters very far, or anywhere, really.
Well, it comes back to the question, my lord, as to how one characterises the challenge, because if one regards it as a challenge to the decision that was made I say by the then Minister and Parliament, by endorsing it, by not exercising its power to strike it down back in 2001, then it is more akin to a challenge that a piece of delegated legislation is, well, it is a challenge that a piece of delegated legislation is unlawful, than it is a judicial review claim in the conventional, in the sense of an attack on a particular decision. And that's the context in which the government does put forward in this court its contention that the legislation, the delegated legislation, is consistent with the policy.
Yes, all right. Well, if that's all it means, namely, in my view, this is consistent with the policy, fine. But if it were going further, and if it were really intended to say, I am the minister, or I was the minister in 2001 or 2005-06 who considered this, and I took the view then it's really, I think, not admissible as such.
Yes.
But Mr. Rowe, let's get this absolutely clear. What happened to the recommendation in the programme?
Well, there has the recommendation in the programme remains a recommendation.
I meant to ask, what happened to the recommendation in the programme?
I'm not sure I understand your Lordship's question. What happened to it? Does your Lordship
There
mean?
was a recommendation.
Barely.
It's not reflected in the 2006 rules and regulations.
It couldn't have been, in my submission, it reflected in the change in the fees rules, which took place in 2006, because, as I shall hope to demonstrate, the fixed fee aspect of this scheme is actually built into the rules themselves, and that's why I say that's really what needs to be the target.
This is the Rule 8 point.
Yes.
You say it's the rule. It's the water preservation protection rules,
yes,
not the fees regulations.
My Lord,
Your case
exactly.
is that even if they had wanted to, I mean, in fact, what you're having to say is that this recommendation was a waste of time because it couldn't be achieved.
I don't.
No one seems to have thought that until
I don't quite say that.
Your submission. But
I don't quite say that, my Lord. I mean, I accept the best answer I can give to Lord Wilson's question is that there is no evidence that the recommendation was, so we can see it wasn't acted upon.
Is there any evidence that the recommendation was considered?
I don't believe so,
Even if
my
it
Lord,
isn't a recommendation, Mr. Rowe, even if it isn't, is there any evidence that anybody looked at the 6 models and asked themselves which one they preferred?
There is some evidence to suggest that, but I have to treat it with some caution because, as has been pointed out, there are difficulties with chronology.
It appears to relate to 5 years before the
Precisely.
document.
Yes.
I mean, and Mr. Goddard's position is very odd because he was one of the authors of the recommendation, so presumably put his name to it. He then swears an affidavit where he seems to go off on a different tangent. And when the judge tries to get some more evidence about what's been going on, Mr. Goddard turns out not to be available because he's gone off somewhere else. I mean,
yes,
that's the difficulty of everyone. So it is. So I mean, it seemed to me that you really have to rely on your rather sort of narrow legal point that whatever the recommendation was, it couldn't be achieved under the rules as they then stood, which is an interesting point. But
yes. Well, I don't know whether that's a convenient. Probably isn't at 2:30. Never is a convenient moment to have lunch. But I think that was our plan, wasn't it? Or have I misremembered?
I thought we were postponing your lunch hour until 3 o'clock.
Oh, were we?
Mr.
Well,
Rowe,
I'll
but
carry on in that case.
If anyone either here or in Trinidad and Tobago is particularly hungry, we could always consider adjourning early.
I wasn't making an application to change the timetable. But
How long are you going to be? In fact, you're going to go over the adjournment.
I think so. Yes, inevitably.
Yes. Well, we'll go on a little bit.
yeah.
We'll go on. Are you happy to go on, Mr. Hussain?
Yes, my Lord.
We'll continue till 3 o'clock this time, 11 o'clock Trinidad and Tobago time.
So, my Lord, if I might just to return to the scheme of my submissions broadly as per the case. As I've said, I think already, we accept as regards the meaning of the policy, that's a matter for the court, not for the minister. But insofar as the policy gives room for or requires there to be exercises of judgment by the minister and or by Parliament in terms of the decisions that are made about how to set a relevant scheme up, then those are matters which are matters for the government and for Parliament, subject, of course, to the usual public law constraints. Just to make that good, my Lord, that's Authorities Bundle 3, tab 22. Which is the Tesco stores and Dundee City Council case. It was a planning case about the relationship between the policy in that case, the development plan, and the planning decisions that were taken. The passage that we rely upon in the judgment of Lord Reid is at page 1723. It's paragraph 19. Just before that paragraph, Lord Reid has said that in this area of public administration, this is a few lines above 19, as in others, policy statements should be interpreted objectively in accordance with the language used, read, as always, in its proper context. But the qualification we submit is important. That is not to say that such statements should be construed as if they were statutory or contractual provisions. Although a development plan has a legal status and legal effects, it is not analogous in its nature or purpose to a statute or contract. Often observed, full of broad statements of policy, many of which may be mutually irreconcilable. Many provisions are framed in language whose application to a given set of facts requires the exercise of judgment. Such matters fall within the jurisdiction of planning authorities, and their exercise of their judgment can only be challenged on the ground that it's irrational or perverse.
What was the nature of the obligation to consider the development plans in that case?
That was, I think,
Simply
Scots law has
the common law
express
Duty to have regard to.
have regard to.
in statute or in common law?
The statute. The statute
Yeah,
says
I think
have
we-
regard
Statute
to
says it.
plan and other material considerations.
Thank
We've
you.
actually considered this more recently in a case called Hopkins Holmes, I think, where, but I mean, it doesn't detract from this, except it rather emphasises the importance of looking at the language in context.
Yes.
And there I said that actually the particular policy in the Tesco Holmes case was fairly specific.
It looks as if it might be section 25 at the top of page 1717. Is that right?
Yes, that's it. Yeah,
Okay, got it.
I put it in the case, but I hadn't referenced the
Yes,
paragraph.
thank you
But
very
you're right.
much.
It's in accordance with, actually, in this case.
Yes, it is.
Section, is it, or is it?
Well,
Foot of
that right?
1716, is it?
1717.
Ah, oh yes, I see.
and there's other material considerations.
There seem to be two, well, section 37 on page 1716
Yes, it's
says
bottom
have
of
regard to.
1716 and top of 1717.
So I think,
Less material.
in a sense, I think both Barnworth and I are right about that, because it says both things.
Well,
But,
it's sort of developed. I mean,
yes.
over long, and I deal with it to some extent in my judgment in the Hopkins case. But I don't think it's got much to do with this case.
No. Well, it has to do with this case only that it reinforces, I submit, my point that when one looks at the national environmental policy on that aspect of the attack, one has to look in the wording of it to the extent to which it is being prescriptive, and look to the extent to which it is allowing, as it were, room for a debate as to how it ought to be implemented.
I mean, you may be helped by the later case to the extent that we were there dealing with something called the National Planning Policy Framework. And we were saying that there was too much of a tendency to treat it as though it were sort of prescriptive, whereas in fact the nature of the document implied a rather more general approach, which I think is the point you're making here.
I'm grateful. That sounds promising from my point of view. Can I then, my Lord, go to the scheme? And one ought to start with the rule-making power. This is Authorities 1, again, tab 2, back to the Environmental Management Act. page 1029. Section 26, the Minister may, in accordance with Section 27, Section 27 I needn't take you to, but it requires consultation with
1029.
proposed rules being put in the Gazette. The Minister may, in accordance with Section 27, make rules subject to negative resolution of Parliament, which we say is important, for the following. And then there are various things set out. The relevant one for our purposes, I think, is paragraph C. Procedures and standards with respect to permits or licenses required for a person to install or operate any process or other source from which pollutants will be or may continue to be released into the environment. And we should also look at the rulemaking power in relation to fees. That is at 96, section 96. The Minister may make regulations prescribing matters required or permitted by this Act to be prescribed, or necessary or convenient for carrying out or giving effect to this Act. There's a rather general provision there.
Yes.
That's why we accept that, at least in theory, depending on exactly how it was done, it might be possible, might be within the vagaries of the Act to devise a much more elaborate scheme which had different fees for different occasions and so on. But then the specific power that concerning fees is at subsection 2, without limiting the generality of subsection 1. The Minister shall have power to prescribe the amount of charges and fees payable to the authority for or in relation to applications, licenses, permits, or for the provisions of services or materials provided by the authority to any person.
Well, isn't that pretty general?
Yes, I mean, that
I mean, you're accepting that there is the power.
I think we accept, yes, that's the, yes.
Your point is on the actual...
It's on the rules themselves, yes. Yeah. We accept that really, but because even regardless of whether subsection 2 is wide enough, subsection 196 makes it wide enough for those purposes. Yep. But we're concerned, of course, with what was actually done.
Yes, let's go to the rules.
So the rules themselves are at tab
It's interesting
5.
there that you can make rules for the manner of regulation for the manner of implementing policies and programmes referred to in 61B, which would include the water programme.
I think it would, my Lord, depending on what it says in section 16(1)B, which was ahead of me. Yes.
And I think that's the power under which the water management programme was developed.
Yes.
So that if there was anything inadequate about the regulations, he could make some new regulations, I suppose.
The rule-making power I've already identified is one which is required to be laid before Parliament for on the negative resolution procedure. That's not specified in relation to the fees themselves, but the rules themselves are laid before Parliament and were, I think it's uncontroversial, laid before Parliament. And in their form as enacted there in tab 5 of the authorities bundle, as I've said. We're concerned with Rule 8. Can I just take your Lordship to that? That's at 1080. And your Lordships will see the scheme. It's where any person releases a water pollutant into a receiving environment outside the permissible level that is likely to cause harm to human health or to the environment, the authority may at any time notify that person to apply for a permit. A person granted the permit shall be required to pay the prescribed fee.
Yeah.
The prescribed fee is defined in the definitions part of the rules, which is Rule 2, page 1076. top of that page as the fee prescribed by the Minister under section 96(2) of the Act.
So it's the fee, is it? Is that the point?
The fee, that's the point.
Why can't,
Not fee or fees, is that it?
Yes, that's
why can't you prescribe under section 96(2) a fee which depends on the circumstances?
because the language of it isn't, in my submission, wide enough to admit that when one looks at how it's described in the water pollution rules themselves, shall be required to pay the prescribed fee.
Well, if the
Doesn't...
if the fee prescription, i.e. the fee regulation, said that the fee will be X dollars per tonne, or if it's a liquid pollutant, gallon of a particular type of pollutant authorised to be admitted, why can't that be the prescribed fee? That's a volume based, that's model, can't remember if it's 4 or 5, but that would be a prescribed fee, wouldn't it?
One can see that something which was, as it were, fairly mechanical in its operation could be described to be a prescribed fee.
Well, some
I accept that rather like
If you were
yes, I
right
can see
on
that.
this, if you were right on this, but they are right about the meaning of paragraph 2.3, then perhaps it is the fee rules which are contrary to law, because they don't enable section 31 to be given full effect.
If they are right about policy, then that, I can see that might be the right analysis. Yes.
Anyway, the basic point is this a prescribed fee?
Yes. I say on its...
Where would that take you? Because I mean, really, this seems to be new. As far as I know, this point hasn't been ventilated before. And certainly the authors of the water management programme didn't think there was any varies problem about what they were proposing. But if you're right on this, well, it'll have to go back for someone to sort of work out how to get the rules right.
Well, my point about this, my point about this, my lord, is it's not so much a varies point, but it is that the scheme which prescribes the fixed fee is essentially the water pollution rules, in my submission, which are the rules which have been laid before Parliament. It goes really to my point about the way in which the court should regard the exercise by the minister, subject to Parliament's oversight of the power.
No, but that's back in 2001 when we hadn't got the management report. And the whole point is that no one sort of reconsidered in 2006 how to implement those, at least that's part of the point, how to implement those recommendations. And you know, if that involved new regulations or new rules, well, so be it. But
that would be an attack on the rules rather than regulation. Your point is, as I understand it, Mr. Rowe, right or wrong, that the rules stipulate a single fee, and the regulations to which the attack was directed in the court below has to fail for that reason. Is that it?
Well, yes, that is...
Right.
It's part of the point I make. Yeah, I mean,
I'm sorry if I've understated it.
But this is relevant. I sort of lay all this groundwork, as it were, because it's relevant to the way in which one then looks at the challenge based upon 2.3, because one is saying.
I am troubled by this because the thing that triggered all this was the laying of the amendment regulations in 2006. And they say, well, no one's actually given effect to the recommendations in the programme. Now, if you had come back and said, well, too bad because you can't do anything about it because the rules don't allow it, then I'm sure someone would have come back with amended to include a challenge to the rules. But to raise that as an objection at this rather late stage does seem to be slightly unfair, isn't it?
Well, can I develop, my lord, our principal submission as to why, in fact, the supposed incompatibility between the polluter pays principle and the policy is not really there, and that point is not a sound one, because if that's right, then that deprives
the incompatibility.
Well,
not between the policy and the polluter pays principle.
Between the not the policy, between the rules and the polluter pays principle, as adumbrated in the policy.
Between the regulations and 2.3, is that it?
Yes.
Yes, well, the scheme which is enacted as a consequence of the Water Pollution Rules 2001 and the regulations, the fees regulations which go with them, and I do contend that the fees regulations essentially followed from the scheme of the Water Pollution Rules.
So this is basically your paragraph 43, is it in your case? Perhaps a little more widely, perhaps...
A little more widely, but yes, essentially, my lord, that's right. But can we start this by looking at what the rules themselves actually, what the scheme itself actually requires or permits the authority to do in the case of anybody who makes an application. The relevant bit I think we can pick up at Rule 13. This is on page 1082.
Right.
So, subject to sub-rule 2, the authority shall, within 30 working days of receipt of a complete application under Rule 10, grant or refuse to grant, with or without conditions, a permit to the applicant. And there's provision about further information and so on. And then, more importantly, perhaps for present purposes, 15. There are obligatory and discretionary aspects to what the authority does when it grants a permit. So 15.1 is what the authority shall establish. The pollutants authorised to be released, the quantity, conditions, concentrations the permittee may release, the exact location where the sampling of the release should be performed, and reporting requirements. And then there are discretionary provisions after that, conditions that they may establish, including the following requirements. The permittee shall take all reasonable steps to avoid all adverse environmental impacts which could result from the activity, minimise the adverse environmental impact where the avoidance is impractical, and mitigate the impact where the impact cannot be avoided. Now, there's provision for monitoring. Further down at F, the permittee shall at all times properly operate and maintain all facilities and systems of treatment and control which are installed and used by the permittee to achieve compliance with the permit. Over the page, that the permittee shall at all times carry out and maintain best management practices, pollution and prevention measures, adequate laboratory controls, appropriate quality assurance procedures, and backup or auxiliary facilities to achieve compliance with the permit. There are provisions about what happens when there's non-compliance with the permit. That's at letter K, reporting obligations. That requires them to report a description of the non-compliance, if it hasn't been corrected, how long it's going to continue for. And then at 4, in determining the conditions of a permit, the factors to be considered by the authority shall include, but shall not be limited to, and there are various factors set out there: the industrial profile of activities, the volumetric release rates of effluents.
So it should be actually a hugely sophisticated process of analysis which leads to the fixing of particular conditions in a particular permit. Am I right? In theory, at any rate.
Well, it can be, because that's what the authority has the power to do.
So they ought to, at the end of the day, have a pretty good idea as to whether, assuming these conditions are complied with, the licensee will be polluting to an appreciable extent or not. And the argument then is that they should have, with that idea, fixed a fee which, in some measure, so to speak, would compensate for the permitted, expected residual pollution.
Well, that is essentially the legislative scheme which my learned friend says is impelled by the terms of the policy.
Or at the very least, establishes a sinking fund to which everybody contributes, even if the contribution is the same by everybody.
Yes, well, what one could, of course,
I mean, the premise of all this is that you're not going to, you're most unlikely to eliminate, if you start off with a polluting enterprise, you're most unlikely to be able to eliminate all pollution, isn't it?
yes.
You do your best.
And 15.2a Roman 2 recognises that in terms, doesn't it?
Yeah.
Yeah.
Sorry, on 15.2a.
A2, top of page 1083.
Oh, yes.
Where the avoidance
Minimise
is
the adverse
impractical.
environment impact where the avoidance is impractical.
And I think
Yes.
we've seen elsewhere in the programme that there is there's a general recognition that at least in this stage of environmental pollution regulation, stopping it altogether is impractical.
Yes.
Stopping emissions which cause it is impractical, even though there are things you can do to alleviate it
Yes.
thereafter.
Can I then go in that context back to the policy?
Just before you go,
Yes.
am I right in thinking that there's nothing in the rules or the fees regulation which enables any other charges to be levied? The conditions are all what I might call non-financial. Or obviously they may involve the polluter in putting his hand into his own pocket to comply, but there's no other provision for another charge or payment for the pollution.
Well, I'll check that, but I think Your Lordship's right that there isn't express provision for other charges to be laid.
So it's the fees in the fee structure or bust so far as generating money is concerned.
I think that's right, but I'll if I may have double check that.
Yes, well, I'd be grateful.
Right.
So I was going to go, my Lord, back to the terms of the policy and look at the suggestion that the scheme that we've just looked at is inconsistent with the policy and not in accordance with the policy and therefore unlawful. And I took Your Lordship earlier through, I think, all of the relevant parts of the policy. Insofar as we're dealing with matters other than the point upon which my own friend focuses, 2.3b, in my submission, there really is no question but that the scheme, as set out under the rules of 2001, which were reenacted, which have not been altered since, and the fee element has been reenacted with the same fee, are entirely in accordance with the policy. If one goes to the specific section of the policy which talks about water pollution, I took Your Lordship to it earlier, but it's the one at 3.7, 1223, one sees, I say, essentially a description of the policy, of the scheme, rather, in the rules, as it exists. Little I, control water pollution through a system of permits for facilities that are the source of any release of water pollutants, based on the polluter pays principle, which will set pollution limits or performance standards for water. The cost of pollution prevention or of minimising environmental damage due to pollution will be borne by those responsible for pollution. That, I submit, is an entirely fair description of the scheme as it exists, because you cannot, if you are conducting an operation which is emitting pollution above what's described as the permissible level in the rules, then you're not allowed to do it any longer unless you have a permit. So you are prevented from doing so unless you have the permit. And if you have the permit, then you may be, and in practice, no doubt often will be, required to comply with, as it says there, pollution limits or performance standards.
And the last sentence, the answer is the condition, is it?
Yes, the cost of pollution being borne by those responsible doesn't mean you have to doesn't have to mean that you have to cough up money. It can mean that we're telling you that you're going to have to do various things and you're going to have to pay for them yourself.
Yeah.
So that fits in my submission entirely within the four walls of the polluter pays principle. This then really just leaves section 2.3, which you'll recall we find on 1213. I do underscore, as I've already mentioned, that this is, although it's expressed in concrete terms, money collected will be used to correct environmental damage. It is, as it were, behind two preambles that make clear that it's not necessarily to be, or it isn't to be read, I say, in quite such black and white terms as if it were a statute. It's first of all behind the words immediately above letter A. Important elements of the principle are, so it's an element of the principle. And it's also behind 2.3 basic principles. Government's environmental policy will be guided by the following basic principles.
May I ask, is it a fair reading, a fairly clear reading of this part, this important element, that money collected means from the charges which are levied? Look, I bear in mind that if you look at the rules about the fund, there are all sorts of different sources of income for the fund. But here, money collected means from these charges, does it?
I think I must accept that, my Lord, yes, because it comes immediately after the word charges are levied.
Yes. And those are charges which entitle a holder to generate pollutants, the specified quantities of pollutants. And it's a fair assumption that they may, but not necessarily will, cause environmental damage.
Yes, I accept that.
Okay.
The real nub of it is whether it is right to say that in the light of the words will be used to correct environmental damage, situated as they are in the policy, it is unlawful to have a scheme which does not actually have the money coming from charges going to the Environmental Management Authority for it to go round itself in some way, either correcting environmental damage or procuring the correction of environmental damage. And in my submission, that's not a reading which is necessary. Because
do we have any information about the fund and what happens to it? And we were shown Section 72. But I couldn't find anything in the policy which talks about the fund. Do we have anything else about how the fund is administered and what it's used for?
Well, I don't think that we do. Again, I'll have to my list of.
But in a way, this goes to the point you're just making
back.
about to what extent it's part of the authority's duty to go out, rolling up
Yes.
things and doing.
Yes. I mean, it's certainly accepted that the charges that are levied. They're pitched. They're designed to be pitched at a level which funds the administration of the charging of the making of charges, and not just the making of charges, of course, but all the implementation of the conditions. And that's really the foundation of my submission. That actually, this part of the polluter pays principle, as defined in the policy, is being complied with, because that is quite irrespective of whether the authority actually goes off and starts clearing things up or whatever it might be that one has in mind by that sort of work. The fact in itself that the authority is operating a scheme which when it detects somebody who is emitting pollutants above a permissible level, intervenes to require that that's got to stop unless you pay a fee, and that if it's to continue, it's got to continue only under certain conditions, which can include conditions, as we've seen, for minimizing and mitigating environmental damage. That in itself is, properly understood, correcting environmental damage. After all, if you've got...
Right, well, I think probably we should break for
Yes.
half an hour at this point, Mr. Rowe, and we look forward to hearing your submissions further in half an hour, and I hope that's understood in Trinidad and Tobago too.
Does your Lordship mean half an hour from now or at 3:30?
3:30.
3:30.